Hey everyone, welcome to our webinar on the Online Safety Act. For those who don't know me, my name's Jon Brunning. I'm a partner here at Fieldfisher, specialising in all things tech and digital. And I also lead our tech and digital regulation initiative, which is helping to support clients to understand and assess and ultimately comply with the broad range of EU and UK regulation, which is happening and right now impacting the tech market. And of course, the Online Safety Act is one of those. Joining me today, we have Jon Higham. Jon has worked at Ofcom for over 15 years, and the latter part of that spent leading Ofcom's charge on online safety, in particular the illegal harms statement, as Ofcom's policy director. If you joined us for our previous webinar, which Jon featured on, you'll know he's a wealth of expertise on this topic. So we're delighted that he's able to join with us and share his experience on it. I'm also delighted to be sharing this with Nicola Margiotta. Nicola is a director in our regulatory team here at Fieldfisher, who specialises in public inquiries and regulatory engagement investigation, including on online safety. So she'll bring a real great insight into how she's been helping clients with engaging with regulators. So on to today's webinar. No doubt, I don't need to tell anyone on the call here that we're getting to the sharp end of the Online Safety Act. The UK enacted this back in the end of 2023, and since then Ofcom has been in overdrive in working to publish consultations and finally published its statement on illegal harms back in December last year. This all kickstarted the timeframe for compliance, the first of which is getting in place illegal risk assessments and then child access assessments. And there's more consultations to follow, and we'll touch on that later. But what we didn't want to do on this webinar is to just recite the Online Safety Act. Firstly, that's kind of boring. Much more important is we talk about the practical questions that our clients have and to understand how Ofcom's looking at compliance and how clients should look at compliance with this act. So to that end, as part of the invite, we've given everyone an opportunity to ask some questions, and we've had a fair number of those across a broad range of topics. So we've spent a bit of time boiling those down into some key themes. So things like scope, governance, risk assessments, and enforcement. And that's what we're going to be talking about today. So hopefully your question will either be answered or as part of the questions we ask or as part of the things that we discussed today. But if not, please drop us a note afterwards or in the chat, and we'll do our best to get to it. So let's start with an easy one, Jon, on this one. As I said, the illegal harms statement was published the tail end of last year. Can you talk a little bit about the key aspects of that, perhaps in terms of who it covers and what does it mean for those people who are in scope?
Absolutely, Jon. So, well, firstly, before I do that, thanks very much for having me. It's always, always a pleasure to talk to you, and looking forward to a productive session today. So in terms of the scope of what we published in December, so broadly that document set out, all of our sort of thoughts and guidelines on what companies need to do to comply with the duties related to illegal harms. There were actually a range of different pieces of guidance that we published in that statement. So it wasn't one thing. It was a sort of a mix of multiple documents, actually. But there were three key ones. So firstly, statement contained risk assessment guidance. So guidance on what companies need to do to assess the risk of illegal content being posted or illegal conduct happening on the services they operate. Secondly, codes of practice, setting out what companies need to do to comply with their safety duties. So what they need to do, in other words, to mitigate the risks they identify in their risk assessment. And the third sort of particularly key bit of guidance I'll flag is our illegal content judgments guidance, which effectively sets out for companies how they should go about judging whether a piece of content that's reported to them is illegal and therefore needs to come down, or not. So that was the scope of the document. In terms of the sort of scope of companies for whom it's relevant and what it means for them, there's a lot of conversation about social media platforms, obviously, and of course they are a big part of the scope of this. But actually, the scope of sort of companies covered by the illegal harms duties in the Online Safety Act is immensely broad. So effectively, the documents we published were targeted at any internet service which enables the sharing of user-to-user content, as well as any search service. So, for example, companies as wide and varied as social media companies, but also gaming companies, messaging services, all in scope. So it's a very broad scope. And I won't go into the full detail, but in essence, if you distill it down, really what the document is driving at is, if you're in scope of the online safety regime, if you're one of those services that I've mentioned that's in scope, then you need to do a really strong risk assessment. You need to think about the risks that your service could pose to people in the UK. And then you need to do the things we set out in our codes to mitigate those risks. But within that, there's quite a lot of variety of expectation. So, we're aware that we are regulating everyone from, the biggest companies in the world, down to, small startups, community organizations that might not be commercial entities. And therefore, what we've tried to do is have a fair degree of differentiation in our expectations. So, if you're small and low risk, what we've striven to do is, basically impose the bare minimum obligations that the Act allows us to. So we're really not looking to have a chilling effect on business or on, community organisations, etc. If, on the other hand, you're either very large or you're small but you're high risk, we set much more stretching obligations. So we've tried to be sort of unashamedly risk-based in our approach, and whilst at its core, what you have to do is assess risks and mitigate them. What that means in practice will vary quite a lot depending on your on how risky you are.
Thanks, Jon. I think it's fair to say you've gone into quite some level of detail around articulating what sizes of platforms and then what your expectations are. And I think that's quite clear in both some summary guidance as well as when you get into the more detail of that.
Yeah. We've tried to. Whether we've achieved in that,
there's a lot there.
We will see.
Thank you. So hopefully that gives a good sort of baseline for us to start this kind of conversation. I wanted to ask a little bit about generative AI, because clearly that is one of the most hotly talked about topics that we see. I mean, we obviously hear a lot of that from our clients and ones who are speaking to us about managing the risks of bringing AI into their businesses. But it'd be great to talk a bit about how you see generative AI impacting user services and how the OSA and Ofcom are looking to deal with generative AI and some of the risks that it creates.
Yeah, I mean, that's a hugely topical question. And so, I'll say a couple of things there. So, firstly, as a starting point, before we sort of get into the detail of scope, we absolutely see that on the one hand, there are tremendous opportunities associated with generative AI, but also, our research and analysis shows there are some significant risks that need to be dealt with. And I think we've tried to highlight in our register risk. We really do see, things like the risk of synthetic child sexual abuse imagery being generated by generative AI, or content which supports fraud, etc. We really do see that there are some significant risks there. In terms of how the Act and our regulatory framework deals with that. So the first thing I would say is that if someone goes away and produces a piece of illegal content using generative AI and then posts it on a user-to-user service, then that is a piece of illegal content and is treated the same for the purposes of the Act as if I had created that illegal content, myself without generative AI. So, the same core obligation to take that content down when it's detected, still applies. And so in that sense, generative AI is absolutely in scope. Numerous of our measures will help, address generative AI, so content produced, illegal content produced by generative AI. So, for example, actually we are going to be consulting on some proposals in the spring where we'll talk about the use of hash matching to produce hash matching to detect and remove intimate image abuse content. Now we're aware that a big problem is generative AI being used to sort of like synthetically generate like deepfake intimate imagery. Our hash matching proposals will absolutely cover that. They won't just cover that, but they'll cover that sort of content regardless of whether it's produced by a person or by generative AI. So it's absolutely in scope. We have some provisions to deal with it. The other two aspects I would flag how the Act deals with generative AI are, firstly, we've seen a number of services, and we wrote an open letter about this in November, which set out the sort of fuller detail of that thinking, that allow the upload of chatbots, user-generated chatbots. In other words, like Character AI, I think is the example that was in the newspaper. Now, if you are operating a service that is a sort of aggregator that allows the upload of like user-generated chatbots, and if those chatbots are then available for other users to use, then for the purposes of the Act, we would consider you to be a user-to-user service, and you would come into scope of the regulations, which would mean you have to do a risk assessment and you have to put in place measures to mitigate the risks. And then, of course, search services. If you're operating a search service which is powered by generative AI, as a sort of generative AI component, again, that would be in scope.
So lots of areas actually where that's impacting, and I think
with the search service, it's worth highlighting, isn't it, that if your chatbot is using only the material that's on your website in order to carry out the search, then it's not classed as a search service. It's
that's correct.
Its own chatbot function.
It has to be, going to searching two or more websites, basically. So if you're searching the open internet, you'll be in scope. But if you're in a sort of walled garden with just your website, as you say, that would not be in scope.
And certainly, I mean, we touched on how generative AI impacts online safety, but of course, AI is impacting a lot of other areas. And, part of this broader digital regulation kind of agenda, which I mentioned at the start of this, things like the EU AI Act, there's impacts on privacy and GDPR, as well as broader governance issues around AI. So it's one of these things where I think areas where we see clients having to think more broadly about the topic rather than focusing on a one regulation issue. Actually, a lot of these issues are across different regulations, and perhaps the same mitigations and assessments are going to help with compliance across those. So last question on scope, and this is really around some of the scale aspects of use-to-use services. So one of the requirements in the scope area is around service. The service has a significant number of UK users. If you're as one of the tests, it would be really helpful just to understand or give us any guidance on the factors that people need to be taking into account when they look at that aspect of the kind of targeting the UK?
Mhm. Yeah, so we provided a little bit of guidance in the age assurance guidance we published in January. So that covered a little bit of the question you just asked. So we can circulate that, or I can point you in the direction of that text, and you can share it with your clients. And please use that for the definitive position rather than what I say now. There are a couple of things I can say though, which I think sort of help address your question. So firstly, there are 3 tests that are relevant here. So do you have a significant number of users in the UK? Is your service targeted at the UK? And is there, a material risk of harm coming to people? Can your service be accessed in the UK?
Yeah.
And there's a material risk of people coming to harm as a result. And if any of those 3 limbs apply, then you're in scope. The significant number test, we haven't put a sort of definitive number on it. What I would say though is, first, if you're a small service, even if the number of users you've got in the UK is small in absolute terms, if it's large proportional to your user base, we would expect you to be captured. Secondly, I would advise people to err on the side of caution. So to assume you're in rather than assume you're out, basically. Because at the end of the day, this piece of legislation is intended to be broad in reach and intended to provide robust protection for UK citizens and consumers. And if you do, your assessment with reference to those 3 pillars, and you conclude that you're not in scope, that you don't meet any of the 3 tests, we'd expect you to have a strong justification for why, a strong reason justification, and to be able to provide us that justification if you were asked.
Yeah. And no doubt a sort of ongoing monitoring really of that to make sure that may change over time and bring you in scope.
Yeah,
those
absolutely. Yeah, that's a very good point. Yeah.
Cool. So I think that's covered us on scope. I mean, certainly there's a lot more to be said on that, but moving swiftly on to
governance. I think that point about keeping records for the reasons why you've done something or haven't taken a particular action rings quite loudly throughout the guidance, and governance in general is probably one of the key pillars under the Act. So thinking through that would just be helpful to understand whether you can provide any more specific examples about Ofcom and expectations are in the realm of compliance with the Act, particularly about risk management or accountability structures, expectation differentials between smaller platforms and larger platforms.
Absolutely. So should we talk a little bit about governance specifically? What I'd say, so we view risk assessment and governance as absolutely foundational to achieving good online safety outcomes, because fundamentally you can't protect people if you don't understand the risks you're posing to them. So we sort of see governance as like just absolutely fundamental. It's very important to us, and it's going to be in the first year of the regime one of the areas I'd really expect us to major on in terms of compliance. In terms of our expectations, we've set out a number of things in our codes of practice, that like the expectation that you have a senior accountable person for your online safety duties, like the expectation that senior governance bodies review the company's approach to risk assessment on a regular basis. I could go on, but I think rather than listing individual expectations, what is more helpful for me to talk about is the spirit of the rules here. And I think the underlying spirit behind our thinking here is, what we want in terms of governance is we want people at the top of your organization, in the upper echelons of your organization, to be feeling accountable for managing risks, to have risks reported to them, and to be very aware of and plugged in to risks, And ultimately, we want, really the sort of upper echelons of in-scope companies to be just as aware of and feeling just as accountable for safety risks as you currently would for commercial risks. So that is, as I say, that is the spirit of what we're trying to achieve. We're actually quite flexible, or we seek to be quite flexible in how companies achieve that. We've tried to tailor our guidance so that, there's a way of complying, whether we've given people flexibility. We recognise that big companies with more established governance structures might seek to comply in quite a different way from, small startups with fewer people and fewer established structure. But what I said about accountability and visibility of risks at a senior level is fundamentally what we're driving at, and that's the spirit behind the rules. Does that make sense?
I think it does, and I think it's really interesting, that point about those at the top of the organisation who are accountable, fully understanding the risk.
Yeah.
And that means that it's not just about a paper reporting exercise and a compliant tick box. It's genuinely about those at the top of the organisation paying proper scrutiny to what does this actually mean? Okay, I've got some numbers, that looks good. What's underlying that? I've got the qualitative data. Can I have some quantitative examples that go with that? And then you'll really have a proper chain of accountability, reporting and records to demonstrate to yourselves. If you come and ask, tell me about your governance structures in relation to the OSA, how do you make sure that they're effective? What else could you be doing in that kind of sphere?
Yeah. I think that's right. And what I'd also say here, just to sort of reflect on our approach to, I guess, to enforcement, right? I think we want to work with companies to. Our objective is compliance, not enforcement, right? And I think, so if companies have made a good faith effort to do a robust risk assessment, and there's something which isn't quite right about it in our view. Generally, our first port of call would be to have a more sort of informal supervisory conversation and say, look, this isn't quite right, we think you need to change it, rather than to reach straight away for the sort of big stick of enforcement. There may be cases where someone is just, obviously acting in bad faith or has breached the rules egregiously, but we might need to go through the gears a bit more quickly and reach for that sort of enforcement lever. But generally, if someone is acting in good faith, our preference would be to use that sort of supervisory engagement as our first port of call to sort of bring people into compliance before we, go down the sort of formal enforcement route.
I think that's really helpful. It brings us on probably quite nicely to risk assessments and overlapping. I know, John, you were going to make a couple of comments about overlapping regimes and reusing of material.
Yes, for sure. I mean, that's certainly where. I mean, it's interesting when we talk about governance, and I was just, as you were talking, reflecting a bit on the position under the Digital Services Act, which we've obviously been working with clients on the last year or so, and expect a number of those on the call are also working with. And it's interesting to see the approach that the DSA versus the UK takes on online safety. DSA is much more, I would say, procedural about it, and in some senses retrospective in the way it looks at online content, whereas I think the Ofcom and the UK position is a lot more about proportionate risks and actually trying to address risks. So it's a little bit less do the following steps and you comply. It's about risk assessment and then addressing the risks that you identify. As you said, John, there's lots of ways that might happen. I think what is useful to say is that, and something that we've been finding with our clients, is that a lot of the work that is done on that, notwithstanding the slightly different regulatory approaches that are being taken in the EU and also in other regulations, whether that's the age assurance guidance and others, is that there's actually a lot of overlap or things that can be reused, frameworks and risk assessments that can be reused. And I think part of this is really about thinking, well, what do you have in place already, and what can you, how can you tailor that and use that as a baseline? Because I don't think what you're asking for in all of this is start from zero, work your way up, because actually a lot of organisations will have takedown policies, they will have internal policies in place to address content there, whether it's driven because of a revenue reason or because of a reason about reputation on the platform.
Mm-hmm. Yeah, I mean, absolutely. I think, we recognise a lot of companies have been thinking about trust and safety for many years now. And, the bottom line for us is we want people to be doing a good risk assessment. We want them to be protecting their users. We want them as part of that to fulfil the requirements of the Act. If you've got stuff in place that does that already, absolutely use it. From our perspective, we just want people to comply. Compliance doesn't necessarily mean starting from scratch, tearing up everything you've got before. If you've got good stuff that meets the requirements, absolutely use it.
Yeah, that sounds good.
I think as well it's use it, but also learn from it. So many of the platforms have now been through the first cycle of risk assessments under the DSA for the large platforms. They've been through that audit process. Yeah. There's quite a number of lessons learned, I think, that those platforms can bring in. Is that something Ofcom will expect to see reflected in the risk assessments where relevant? For example, we saw this in the audit and risk assessment in the DSA. It's clearly relevant under the OSA. Have you made a change as a result of it?
Yeah, I mean, I think that, so as regards risk assessment, I think the bottom line is, what we're looking for is for people to have thought very seriously and hard about the risks, and also to have taken a really evidence-based approach to doing that. And if you've got evidence from your work on the DSA that is pertinent to your assessment of how risky your platform is, absolutely you should be using it to sort of do that assessment. I think the other thing I would say about risk assessment is, again, there's a degree of differentiation in our expectations here. I think we would expect more of the sort of biggest, most sophisticated companies than we would of a very small entity. So there is a degree of, we want everyone to think hard about risks. We want everyone to take an evidence-based approach. We want everyone to be able to show that they've thought about the sort of 17 categories of illegal harms that we identify in our risk assessment guidance. And we want everyone to be able to show that they've thought about the risk factors that we have identified in our risk profiles. But in doing that, I think we would expect the bigger companies to go that extra mile compared to smaller companies.
I think that's clear as well, depending on risk, where you've got a really clear guidance, haven't you, about core and enhanced inputs.
Yes, we do, yeah.
Into the risk assessment and where those come into play. And it's clear, with that, the bigger multi-risk, but also the small high-risk platforms, that's where that's more likely to come into the fore, isn't it?
Yeah, that's right. Yeah, I think the bigger if you're big or if you're risky, we'd expect you to use enhanced inputs. If you're small and you're low risk, then we would expect the core inputs are much more likely to be sufficient.
And in terms of risk assessments, obviously that's the first time people are really, in terms of the deadlines that come up, it's the first one, the most immediate one on the horizon still in next month, mid next month.
16th of March.
So 16th of March. So when people have carried out those risk assessments, what's your expectation about, firstly, what they do with those? I mean, I don't think there's an expectation that they send them to you. I don't think you want to see 1 million risk assessments on your desk. But in terms of what they should do in terms of keeping those under review and upkeep.
So I can say a couple of things on that. So firstly, we expect you to keep a record of your risk assessment. Secondly, you're right, we are not going to look at everyone's risk assessment. There are hundreds of thousands of services in scope of the Act. It'd be unfeasible and unnecessary, I think, for us to look at all of the risk assessments. We will be reaching out to, a subset of larger or riskier services. primarily the services we're supervising,
Yeah.
and asking them to send in, their risk assessment. So we will be asking for the risk assessment of a sort of handful of, well, more than a handful, but a select number of people. Then, in terms of, I think part of what you're getting at with your question is, how do you keep your risk assessment up to date? And I think we want the process to be very dynamic. So, as you guys will know much better than me, you're operating in a very fast-moving space. Technology moves quickly, departments adapt, they're facing change quickly. And I think, therefore, at a minimum, we'd expect an annual review of the risk of your risk assessment. We would also expect, whenever there's a significant change to your service, that you should revise your risk assessment, even if it's outside of that annual cycle. So, if you are launching a new sort of feature, rolling out a new functionality on your service, we would expect you, for instance, to redo your risk assessment and assess whether that change sort of changes the balance of risks on your service and what you need to do to mitigate them. So the idea is that the risk assessment is a living document, and that the process of assessing it is quite a dynamic one.
Oh, that's really helpful to hear, and I think so useful for anyone who's a product council type role within organisations, because it's just another piece of regulation that you need to factor in when the business is looking to roll out some new functionality or a new product. The Online Safety Act is one where that will need to feed into the assessment and input for the business.
It's worth also highlighting its changes as well, isn't it? It's not just kind of rollout of the new.
Yeah.
And there's some slightly not hidden things about if you're changing your content recommender systems with design adjustments, that even if it's not substantial in the way that you need to change your risk assessment, you still have a whole loop of governance about checking what the impact is, training and records for the team. It's a bit into the weeds, but
yeah, I mean, I think the point about recommender algorithms is an interesting one that you make, and I think what we've said there, we're aware that many companies, when they make changes to their recommender algorithms, will test those. The sort of A/B testing, or to see what the impact is in terms of how that affects user engagement or what have you. I think what we're asking is, as well as in that sort of on-platform testing, testing for sort of commercial metrics, also test what impact the change is going to have on safety. So you go into it with your eyes wide open.
I think that's a really interesting point. And just thinking about content moderation and moving on slightly, some platforms and organisations may use third-party moderators, for example, or contract out certain functions to third parties. Does that mean that a service can contract out its responsibilities under the Act to those organisations, wash its hands and walk away, or what's the position there?
I wouldn't be very good at my job if I decided something impressive. No, so listen, I think at the end of the day, the bottom line is, if you are the sort of in-scope entity, if you're the in-scope service provider, it's you that is responsible for ensuring that your service operates in a manner that's compliant with your duties under the Act. Now, of course, people may wish to contract out aspects of their content moderation function. That's fine. That doesn't allow you to wash your hands of your duties under the Act, though. Rather, you would need, through the contracts you have with your contractors, to secure that that they were performing in a manner consistent with your company's with your company's duties.
I think that's really helpful. So a bit of a reminder for everyone on the call, if they're not already, to go and look at those third-party contracts and check that there are mechanisms in it for monitoring online safety, and that they do have the ability to enforce some levers if necessary, if they find there's issues with it.
Yeah, I think we see that, getting across lots of different regulation. I think this is one of those areas of compliance with this kind of the new sort of world of regulation of technology that's happening across Europe is that, yes, there's all of this compliance piece, and that's the very obvious bit, but under the surface, there's a much harder question around supply chain here, and it's not just online safety, but all of the other regulations that businesses on this call will be impacted by, and actually pushing down these requirements, whether they're expressly required by the Act in certain instances, or because they are a natural implied requirement as part of this, because, as you say, John, you are the entity who ultimately is responsible for compliance, ensuring that those contracts you have where it touches on the regulation or supports the compliance function has that level of rigor in them to ensure that you've got that, as you said, contractual levers, you've got the right caps in place, you've got the right compliance requirements to push down.
Really important. So thinking wider than that, and the lovely topic of proportionality, it's a bit of a golden thread that runs throughout the OSA and the guidance. The scale of content out there though is in the millions and the billions. Even where platforms are implementing all the measures, and even if they think they're doing their best of jobs, there's still going to be content out there that either they can't prevent it being uploaded, can't remove it in time, haven't been able to identify it. Any thoughts to share on that, if platforms have either taken all the measures or got a clear justification as to why they've taken a certain approach?
Yeah, I mean, absolutely, Nicola. So, I mean, there, as you say, proportionality is a golden thread running through the regulations, and what we're looking for is for people to put in place proportionate systems and processes to to detect and remove harmful content. Now we know that no system, process, or tool in the real world is going to be entirely fail-safe. And even the best systems, processes, and technical tools will unfortunately let some illegal content slip through. And listen, that we're not therefore going to hold people to a sort of standard of perfection and having zero illegal content on the platform. If you've done a good risk assessment, if you've complied with our codes, if you've got proportionate systems and processes in place, but nonetheless, because nothing in life is perfect, some illegal content does slip through the net onto your service, then that would not make you non-compliant. Like if you followed the codes, you've done the risk assessment, you'd still be compliant with your duties. So we're not holding people to a sort of impossible standard of perfection here.
I think that's really helpful to understand and might give some reassurance to those on the platform kind of who have not done one of these before, and the regime is new because essentially they've gone from no regulation in this sphere to full regulation and scrutiny in the sphere. So I think that's really helpful to understand. With that in mind, will Ofcom be sharing some examples of good or best practice or not so good practice from the first batch of risk assessments you look at?
Well, I don't know about the risk assessment, but what I will talk about here is transparency. Which is, one of our sort of real priority focuses. So we are going to be, as you know, once we've defined who the categorized services are in the regime, we're going to be issuing transparency reporting notices to those category 1 and category 2A services. And we will then be producing an Ofcom transparency report when individual companies have produced their transparency reports, and we'll use that absolutely to shine a light on good and bad practice coming out of the transparency reports. And I think more broadly, we recognise that reputation is a powerful lever. It's one of the most potent levers we have, and therefore I think over the years generally I would expect us absolutely to praise the good and or praise good practice and also call out bad practice where we see it. We think that's really important and sort of helps drive the right incentives in the sector.
Okay, Tulisha, you had some interesting questions about transparency notices and approach.
Yeah, Yeah, I think it's interesting to hear. I think you'll be tailoring some of those notices. I think it's quite clear that that's going to be more tailored to the organisation, which I think is going to be really helpful for those organisations, because it's clear what you're not trying to do is blanket everyone with the same request. And I think certainly when we've dealt with notices for clients which have come through from Ofcom and how do we respond, what's really helpful is the acknowledgement that there is differences with all these services. And you pointed out there is a large group of diverse category of services which are in scope of the Online Safety Act, not just the social media businesses, but lots of different other types of platforms,
forums, dating
all these types of services.
Yeah,
as you say, there's a lot there that covers all with different types of risks and different types of approaches and histories, right, with all this stuff.
Yeah.
So I think that tailored approach is much more helpful for clients, and I think also just making sure that they feel like they can respond in a way that's not going to throw them under the bus, because I think some of this stuff is a little bit of your information. Do you want to say, for the benefit of everyone, the best practice here? The clients, I think, will just want to be careful about making sure that the information is they have is obviously accurate about what they do, and make sure that it's tailored to their particular, rather than giving generic responses.
Yeah. I mean, I think you're right. I think we will be trying to tailor those those notices, and we think that's important. We think that's how we get to the sort of best results. Not just with transparency, but with the regulations generally, because it's such a diverse set of entities that we're regulating. It's not always easy to tailor things, but we think it's worth the effort.
That's great, yeah. And I think it's really interesting to hear just generally sort of the point on proportionality. I think throws with all of this is there's a lot to be said here around the evidence of the actions taken, as well as that sort of showing you've thought about the process, and you've documented the process, and you have evidence for it, and you're assessing that. That's really almost going through the process is the part you're looking for.
It's certainly a really important part of of what we're looking for. We want. I think often it's very hard. One reflection I would have: often it's very hard to sort of define up front what good looks like in a sort of one size fits all manner. So I think what you'll see, whilst we've tried to be as sort of clear and specific as we reasonably can to provide regulatory certainty, we've in many cases had to keep a level of had to keep things somewhat high level.
Of course.
And I think where that's the case, what we're really looking for is evidence of the thought process. So I'll take content moderation provisions in the codes as an example. There we're talking about for large services with multiple risks, they have to sort of set reasonable content, like the targets for the time in which they take down content, and also the sort of accuracy of takedown. And we took quite a conscious choice there not to be specific about what those targets should be, because we've seen in other contexts that it can drive perverse incentives if you try and set a sort of one size fits all target time for taking stuff down. So it had to be high level, and what we're looking for there is really for people to describe why they've set the targets they've had, and be able to come up with a justification as to why they're reasonable, if you see what I mean.
Yeah.
I think that's interesting, and it comes into, I know Ofcom's still doing a piece of work about how you evaluate the effectiveness of online safety measures, because of course risk assessments are only the beginning. If you have a risk assessment, it's not just the tick box, here's my form, I'm done now, wait till next year. It's very much so, okay, well, how do I know that what you've done to mitigate against this risk is effective? So presumably things like, well, I've set my target here of content moderation, because that's where I was last year, and I've done some more things so I can make it a higher target for the next year. Hopefully everyone on the call is aware that as of the 17th of March, these duties come into force. Can you give any indication about what supervision and enforcement might look like over the next 6 months, a year for services who are in scope? Are you going to be there on day one saying, show me that you've done all of the action no matter what the lead time, or will there be a bit of latitude?
So I think say a couple of things on that, Nicola. So firstly, you need to do your risk assessment by the 16th of March, no ifs, no buts, and we will be asking, as I say, a subset of firms to show us their risk assessments. We'll be issuing requests for information, asking to see those risk assessments from a subset of firms, not from everyone. So there, that's something you have to do, and then there, I think that is just a clear obligation. As regards to the codes of practice, the sort of position is a bit more nuanced. So the codes of practice come into force from the 17th of March. So the day after the risk assessment have been submitted. From that point, we have the power to enforce against people who are not compliant with the safety duties. I think in practical terms, though, we recognise there are some things in the codes for which there's a lead time to set them up. There are some things that you should be able to put in place very quickly. There are some things we're asking for that not all firms will necessarily be able to do overnight. For example, the requirements we've got around hash matching to detect child sexual abuse material. Putting that in place may take a little bit of time for some companies who are in scope of that particular obligation, because they have to liaise with the relevant database provider, etc. It will be reasonable, pragmatic, and proportionate. I think what we'll be expecting, as regards to the codes, is for people to start taking action from day one to fulfil their obligations under the codes, and to be able to show us that they're doing that. We'll expect people to put the codes measures in place as expeditiously as possible, which means if there's something that can be switched on like that, we'd expect you to switch it on like that. But if there's something which takes a couple of months, if there's a lead time to put it in place, if you are sort of putting that process in place, you're working from day one to do so, you're doing it as quickly as you can, but there is a lead time of a couple of months. During that sort of lead time, it would be reasonable. I would not expect us to take action against you. I think really after 6 months, we would expect everyone to have had time to put all of the codes measures in place. So any sort of grace we're giving people will kind of come to an end then. We absolutely reserve the right to enforce in the first 6 months. We're not saying the rules aren't enforceable, but what we are saying is we'll be reasonable, we'll be pragmatic, we'll be practical. Does that sort of answer your question?
I think that's really helpful for everyone to understand, particularly if there are lead times for significant pieces of work. If you do need to get your data and your metrics in place to understand how you can actually do something in order to mitigate a risk you've identified, then it's really helpful to understand. As long as you're keeping a clear record of it, you could explain it to Ofcom. If Ofcom came and asked, then I'm sure that would be really helpful for people to understand.
Yeah, I think that's right.
It brings me on slightly to a question we had in earlier. So one of Ofcom's 17 categories of harm includes harassment. Do online platforms only need to assess the risk of this happening on the platform itself, or does it extend to users harassing other users of the platform, for example, WhatsApp or in person?
Well, I mean, say a couple of things on that, Nicola. So, I mean, firstly, we recognise from all of the work we've done on our register of risk that many of the harms in scope of this act, are sort of cross-platform harms. I mean, if I look at fraud, for example, you might make initial contact on a social media platform and then move someone onto a messaging platform, more sort of private space to, as the sort of defrauding of that person progresses, just to give you an example. So we recognise that a lot of harms are cross-platform. What I would say in terms of measures to mitigate harm, you're responsible for your platform. we're not looking to make services or make companies mitigate the risk of harms occurring on other platforms. We're looking for you to make your platform as safe as is reasonable and proportionate for you to do so. What I would say though is, think about the risk of harm migrating from another platform onto your platform.
Yeah.
And take steps to,
that external threat scanner.
Exactly.
A development from that is if you know there's coordinated work going off your platform in order to bring your harm on platform, and you've seen it happen before. That's something that you might expect to see in your risk assessment, that there is a risk that coordinated activity could bring this illegal harm onto my platform.
Exactly.
And here's how I keep an eye on that, and I put these measures in place if it does happen.
Exactly. But the bottom line is your responsibility is to make your platform safe, not to make other people's platforms safe. That's their responsibility.
I think that's really helpful. We're whizzing through our time here, and I think we've come to the last section, which is just about the look ahead to the next year or so. You've had your age assurance coming in January, the illegal harms risk assessments, the children's access assessments, just published your violence against women and girls consultation, which for those on the call who haven't seen it is open until I think the 24th or 25th of May. What else is coming down the track this year? What should people on the call be aware of?
Couple of things. So in terms of policy development, we'll be publishing a statement on protection of children at the end of April, and we're also publishing a consultation late in the spring on further steps that we want to add to our illegal harms codes, on some sort of augmentations to the baseline we've already set down, and that will focus in particular on things like the use of automated content moderation tools to detect a sort of slightly broader range of harms. Focus on things like hash matching for intimate image abuse content, stuff of that nature. So that's sort of the next big milestone in terms of policy development. But really, my big message will be we're shifting into a year of action now. We've just come out of 2 years where our main focus has been kind of developing policy. There's a bit of that left to do, which I've just mentioned, but largely what we're doing now is handing over the baton to the regulated companies, and starting to shift our focus to driving compliance with the rules. So I think what I would expect to see from us over the next year is much more of a focus on those supervisory conversations with companies to understand what they're doing, test whether it meets our requirements. Within that, first big milestone is obviously the 16th of March, when everyone should have their risk assessment done by, and hot on the heels of that, we'll be going out to people to speak to them, not to everyone, I would stress, but to the supervised firms, to speak to them about whether they've done their risk assessment. Then, when the children's codes are published, when the protection of children statement is published, there'll then be another 3 months for people to do the children's risk assessment. So that will then have to be done in July, and then those children's duties will go live. So really, we're moving into a year of action now, I think.
And then the categorization and the transparency notices sort of wraps up the end of the year.
Yeah. Sort of tail end of the year, beginning of next, for the categorized services consultation.
Wonderful. Well, is there any other final messages you want to leave anyone with, just in terms of just, if we step back from all of this, and obviously we've got to the detail, any of the key takeaways, from what Ofcom is expecting, just in terms of this? Obviously, we're moving into a year of action, but it'd be helpful just to see anything else you think you should leave with the people on the call.
I think just to think about the spirit of the law here. There's a lot that we've written, and it can be easy to lose sight of the woods for the trees. but fundamentally what we're looking for is good risk management. So fundamentally we're looking for people to do, you know, a thoughtful and evidence-based risk assessment, and then have a clear strategy for mitigating those risks, and the ability to explain why that strategy for mitigating each of the risks is proportionate and likely to be effective. And we want people to move to a sort of more of a culture where they think about safety risks in the same way as they think about sort of commercial business risks, and treat safety with the same degree of seriousness.
Wonderful. That's a nice way to end. Thank you, John. I really appreciate your time and for sharing that with everyone on the call. If we didn't get to your question, please drop Nicola and I a note, and we'll do our very best to respond to you. And as I said, this is all part of this broader digital regulation journey that we, the technology businesses are on as part of, the changes to digital and technology regulation in the UK and in the EU. And there's lots we're doing as a firm on this across different areas. So again, if you want to talk to anyone about stepping outside of the detail of a particular piece of regulation to this more strategic aspect of how do we think about compliance as a business across all of these different regulations, please do reach out to us. Be really happy to help, and we've got plenty of resources which we can share with you to help with that. But to say thank you, John, for that. It was fantastic. So
no, thanks very much. I hope that was helpful.
It was great. Thanks so much. Really
thanks a lot, guys.
And thanks everyone on the call.